All right. I thought I had a camera here on this, but it looks like I don't. Are other people on camera, or are we all just on phone today?
I'm on camera.
Let's see if I can fix this. Ah, I found the problem. Okay. Well, I don't know if that worked or not. Okay. So I guess the first order of business is to call the meeting to order. So I'm calling the meeting to order now. Has everyone had a chance to look over the minutes from the last meeting?
Yes, I have.
How do they look to everybody? Anyone have any changes or?
I have-
This is Chris Cook. You might want to take the roll and ensure that everyone is here and can hear and can speak.
Okay, Chris, you're really quiet. Speaking of can hear, at least from my end.
I'll see what I can do about that.
There you go. That's better. Okay, so let's take the roll and see that everybody's here. I'm Adam. I'm here.
I'm Darcy. I'm here.
Barbara? Barbara, you're on mute. I don't know if you're trying to tell us something or not.
Okay, can you hear me now?
Aha.
Yes.
I'm here. All right, I'm here.
All right. I'm still trying to figure out how to get my camera working on this computer, but it's not happening. So we'll carry on. Kristen, you're here also?
Yes, I am.
All right. And we also have Christine Cook.
That's correct.
All right. Did I do that right? All right, I'll assume I did. Okay, so do we have a motion to approve the minutes from the last meeting?
So move. This is Darcy.
All right. I'll second.
Barbara.
Barbara seconds. Okay. All right, so the next thing I think on the agenda.
I'm sorry. You have a motion with a second. The next step is a vote.
Thank you. All right, vote to approve the meeting minutes from last time. Those in favor say aye.
Aye.
Against say nay. Okay, the ayes have it. It is approved. So the next one we want to go to is the complaint. And I think what I'd like to do, and Chris, stop me if I'm doing something I shouldn't be doing, but I'd like to start out by identifying any attendees we have here who are not among the people in the roll call. Because I think it would be good to have the names on our record of who was here from the public as well.
Okay, I'm really sorry, but once again, so the Open Public Meeting Act says that those who wish to attend a public meeting cannot be required to give their names.
Okay.
If you look at the participants, if you click to open the participants and then you click to open the attendees, you will get a notion of
Gotcha.
who is attending.
Okay. All right. Well, I don't think we're set up yet to be doing public comments on the record, but when we are, I imagine that changes and they have an opportunity to state their names.
If
they
they
want to.
speak, you can ask them to state their names,
Okay.
but just to attend, that is not required and
Gotcha.
cannot be.
Right, okay. All right, that makes sense. So, Barbara and Darcy, did you guys have a chance to read through the comments submitted by Bridget McLeeman?
I did, yes.
I did too.
Okay, so, my take on this is that I also noticed a slight change in the, first I wanted to thank Ms. McLeeman for her comments, because I think they are important. And I also did notice a change from the language of the ordinance to the language of the code, which I know since I'm a practicing attorney that that's not uncommon. But I don't believe that there's anything that we are authorized to do here. My understanding is that we have to operate under the code, and it's someone else's job to figure out how to translate the voter approved charter amendment language into the actual code that we operate under. So my approach to this comment would be to just thank Ms. McLeeman for her comments, and that we trust she's bringing them up with the people who are authorized to address this more thoroughly.
So Adam, by that, do you mean staff?
Well, I don't know, to tell you the truth, Darcy. I don't know who it is that does that. And I think we can get Christine's input, but I wanted to check with you guys first and see if you guys had anything that you wanted to say about it before that.
Maybe I was missing something, but my understanding of the comment was basically a potential conflict in the language, or at least discrepancy. I didn't see anything that the ethics that we as a group or a committee could do about it.
Okay.
Right.
Darcy, did you have the same impression there?
Yes, I agree with that.
Okay. So Chris, do you want to take over from there and give us your thoughts about this? Oh, here we go. Now I can start my video.
All right. So
There you go.
I would be delighted to give you my thoughts about her comments, given that she was a charter review commissioner and so was involved in some of the actions that resulted in the ethics provision being part of the charter. However, I haven't received those comments, so I can't speak to them. I can speak to you about if there is an inconsistency between the charter and the code. And that is, in my view, the charter supersedes the code.
Okay.
And I would not at this point go ahead with creating language or adopting anything that would be inconsistent with the charter. So I would not work on the investigation portion.
Okay. So,
And if someone has Ms. McLeeman's comments handy, could you please forward them to me?
Yes, Chris, I just resent it to you, and it's also
Just arrived right now.
oh, good, perfect. And it's also attached to the calendar for everyone too.
Thank you.
okay. So then I gather that we ought to just put a pin in those things that are brought up in the comment until we get some clarification from whoever's job it is to make sure that the code reflects the charter more accurately.
Yeah, I don't think we can do anything about it. I don't think we're in a position or authority to do that.
Yeah. So the topics that seem to be addressed in the comments are who is subject to the ethics code?
I just saw the conflict in an investigating officer and investigation by the commission or the committee to be a potential disconnect, but not, it could also be read as the committee being in fact the investigating officer. So it's a potential conflict, but I didn't think it was blatant.
I agree.
But then to review what it says at this point is, I mean, we can't do anything about it anyway, so discussing it wouldn't change it.
Yeah, so so as we move through getting back into the bylaws project today, we just need to be aware that if we have bylaws that are going to touch on these subjects, they're going to have to be either subject to change, or we should just wait until we get more information from the commissioners, I guess, the county commissioners, county council, sorry.
I'm sorry, if you could specify what information you would like from me, it would be easier for me to deliver it.
Okay, well, what I'd most like to know is, I guess the first thing would be, who is it that has the job of writing into code what's in the charter? And who will be addressing these comments? And when we could expect to have clarifying language so that we know what code we're operating under.
Well, council adopts code,
Okay,
so that's where code comes from. I am under the impression that I don't need to say anything more about that, but I absolutely cannot speak to whether or when council would adopt changes to the code.
okay. So then I guess, given what you've said so far, I guess my inclination then would be to carry on with our bylaws and make them match what's the language is in the charter. And we'll just assume until we're told otherwise that following the language of the charter is appropriate.
Good with me.
Yeah, me too.
All right. Okay, anything else then on that from anyone?
No,
Nope.
Nope.
Okay. All right, so then next we're back onto the bylaws. Get the right windows open up here.
yeah, I just saw that the clean copy was sent like 12:30, just an hour and a half ago. So I haven't seen all the other, there was a whole bunch of attachments, which clearly I didn't have time to open in that time. But it looked like just the other counties' ethics commission's bylaws and a clean copy of this.
Well, I think we did get a lot.
Hey,
Yes,
Yeah.
and on the 4th of last week, I did send an email
Yeah.
with all of the investigative processes, and I believe right after the last meeting, I sent out the clean copies. And then today at noon, I reattached them to the calendar for ease of access.
All right, so let's see where we are on this then. There we go. That's better. Darcy, was that you who said you didn't see them until today?
No, that was Barbara. I did see them.
Barbara. Okay.
I did see, and I did print out the one that I had previously that still had the blue things in it, but the clean copy
Okay.
I did not see until today. Perhaps I missed it earlier, but I was using the one with the blue highlights and then the lines out and so forth.
Yeah. Okay. So, did anyone see if there were any of the edits that didn't reflect what we decided last week?
I did see some typos and incomplete sentences that I was going to point out, but I didn't see, as
Alright.
far as, at least as far as actual substantial content, no.
Okay, let's go through those then and get them fixed.
Okay, and the 1.2 meetings, it just says, commissions, the meeting shall be held. It doesn't say where or other place.
This is 1.2 point.
1.21. Section 1, it says regular meetings of the commission shall be held
Held
quarterly
Okay,
or at such other place.
gotcha. Okay. So place should maybe be changed to.
Well, it doesn't even
actually,
give you the first place. Shall be held at, there's no way held, it just says shall be held and no place is delineated.
right.
And then it goes on or such other place.
So I think we can just take out or at such other place from there to the end, because I think we've said somewhere else in here that it's going to be virtual.
Just up to quarterly is, it's all that should go there, right?
I think so.
Okay.
Right, that works.
All right.
I also.
I'm sorry, I have a question.
Okay.
So 1.3 says meetings will be held in a hybrid format, allowing participation in person and online. So it's a little hard to participate in person if they are 100% virtual.
Oh,
Didn't
that's
we,
right.
didn't
Yeah,
we talk about having in-person meetings as well?
I
we
thought
did.
so.
Yeah.
We did.
So I guess we have to put a place then in the section 1 then.
Yeah.
I would suggest the County Public Service Center that's set up for virtual public meetings.
Okay. All right. And I see Kristen is keeping up with us. All right. What's the next one?
Throughout the document, complainant and respondent were sometimes capitalized, sometimes not. I don't care which one it is. I just think it should be consistent.
Okay. I would prefer not capitalized.
Right.
That's fine with me.
Okay, that's something I can go through and double check those.
Okay.
Okay, my next one is in 3.1. I don't know if it's been corrected on the clean copy because, as I said, I just got that recently or just saw it. But there
Mhm.
seems to be some spacing problems that things are typed on top of other things or all run together. But maybe it's been corrected since then because it's after investigation. If the is in all one word, now here it's 2 words. And there's more stuff after that, which apparently is in the other one that I didn't see.
So I don't see things running over the top of each other in the clean
Okay.
copy on my end.
On the clean, you probably don't because I'm just I'm trying to get to that section and then just received. clean copy here. Then there was in the sentence on section A, 3.1A, the last sentence may have been corrected in the clean copy, but it didn't look like it was a complete sentence. It was two parts. It says, to that end, the Ethics Commission may request further testimony and evidence on its own behalf time in order to allow for orderly presentation.
In the clean copy, what it says is, to that end, the Ethics Commission may request further testimony and evidence on its own behalf or on behalf of the complainant or the respondent.
Okay, then never mind.
Before we move on to the next one, though, Kristen, I see an extra space in the very first sentence under 3.1 between fines and reasonable.
Oh, right here.
Yeah,
Yeah, there we go.
not a big deal, but
Sometimes with the track changes, it's hard to see those, but
yeah.
here it is.
All right. What's
Also
the,
in C, it says briefs, memorandums, documentation and related materials the respondent or complainant submits should be submitted for review or submits, or never mind. It makes sense this time. Okay.
okay?
Mhm.
All
And
right.
also, I was just questioning on B, on motion of the complainant respondent, or upon its own motion, we may have the investigation have a delay, or is this just because you requested you get a delay because that gives you somebody the opportunity to continue to delay and delay, unless there's some process for either the commission votes on it or, but it sounds like here, just if you make a motion, then you get to have a delay.
I would disagree. The
Okay,
commission has to take the act to temporarily stay or suspend, and the commission would do that by voting.
okay,
So I think the protection you want is built in.
okay, that's fine. I just didn't want it being delayed every month on a motion by somebody who
Right.
didn't hear the end, yeah.
All right. What else?
That's all the picky things I had.
Well, on C, Kristen changed submits to submitted, but didn't we agree that submits was okay?
Yeah, I think so.
Okay. There you go.
Thank you.
Okay. Let's see then. Where are we in this document now?
So I have an issue with 3.1B because it refers to the commission's investigation. And I think that the investigation function is assigned to the staff office by the charter.
Oh, it is?
That is the way I read it.
Let's go back and take a look.
I think that was the subject of the public comment that we got from Bridget.
Part of it, yes.
Yeah.
And it was one of the things we were going to talk about today, correct? Because we didn't have, I thought that we had said last time that there wasn't clear procedures for investigation, and so that needed to be addressed.
Right, and I would suggest not addressing it because I don't think that, so my view is that the commission doesn't do the investigation.
Okay.
Who's got the language from the charter handy?
I think I can pull it up on the screen here too.
It is section 8.13 of the charter,
Um,
and it says, an ethics oversight office shall be established by the county manager to operate an ethics complaint hotline, comma, accept and investigate potential ethics complaints, and provide staff to the Ethics Review Commission.
Okay.
So is that then the Ethics Review Oversight Office, is that something to be created?
Well, so this charter amendment that was adopted in November 2021 says an ethics oversight office shall be established by the county manager to do these things.
Okay. So once the investigation is completed, there's a recommendation either to move on to a hearing or not, correct?
I would assume so,
Okay.
but
And then that would be our responsibility, the hearing.
I believe so.
Okay.
So in that regard, we don't really need to set up a process for investigation since that's set up by the
Staff.
staff.
Yeah.
Well, that simplifies that section.
Yeah.
Okay. So which section was that on? 3.1?
We were, yeah.
B as in boy.
Right.
Okay.
So should maybe that should just be changed to hearing?
Oh, and may suspend its hearing instead of its investigation? Is that
Yeah.
what you're saying? Okay.
Uh.
Yeah, since we're not really investigating anyway.
That makes sense.
Well, but you know what? So 3.1 starts after investigation. I guess that still makes sense if,
Yeah, because it's
doesn't-
done by the other office.
yeah. But I don't know, since we don't know what the investigation is going to look like, then I don't know that whether we're going to need to find a reasonable grounds. Well, I guess we could just leave that.
So in the examples that Kristen sent us of the other places, two of them, Snohomish and Whatcom, I think, did have the commission, the chair of the commission actually do the investigation. And then a decision was made whether it would go on to hearing or not. And we're saying that that is going to be staff, that we are not doing that. I just want to be clear.
That's what I understand.
Okay. Okay.
Well, I guess that's right then. If the staff does an investigation, seems kind of strange, but
What?
Well, it's just a big, well, this doesn't matter. If the staff does the investigation and then I guess theoretically we get some kind of a report about the investigation and then we still are looking for reasonable grounds.
I think that's fair.
Okay,
Yeah, and then we would make the determination about next steps.
okay. All right. I'm on board. So we can, going back to 3.1B then, we can suspend the hearing when we think we have to for justice and fairness.
Right.
Okay, makes sense.
Just want to take a quick look to see where else investigation shows up in the early part of the document to make sure we're not missing one. Okay, so back in section 2, which is on page 2 of the clean copy,
Mm-hmm.
it says that enforcement of the ethics code by the commission is through the complaint and investigation process set forth in Clark County Charter. Okay, that works, doesn't it?
Yeah.
Because we're just referring back to the charter instead of the code. Okay. And then it's B. I don't remember if this is one that we touched on last time or not. It was 3.5 to go over today, or is that review?
3.5.
Looks like we
Right.
did that one, right?
Rights of the parties.
Yeah, I think we did that one last
I
time.
think we did. We went through everything last time.
Okay,
Not
so
everything.
the first sentence in 3.5 talks about the investigation.
You could change that to consideration.
Oh,
Which would,
But wouldn't it just be hearing again? Change that to hearing?
why would you
Well,
change?
yeah,
No, because they don't, they still don't have a right to interfere with the investigation, even though we're not doing it.
but that doesn't belong in your bylaws.
Yeah, we,
Okay.
so if we change this to hearing, what we'd basically be saying is that no one gets to just jump in and participate at the hearing, which seems appropriate to me.
I'm good with that.
mhm. I agree.
Okay.
Back to 3.2, I have that Chris is researching about testimony. I don't remember why she was researching, but maybe she remembers.
About the oath?
Yeah.
Yeah.
So there are other situations. There is at least one situation I know of in which a witness is asked to testify under oath, and that is if the Civil Service Commission is holding an appeal hearing. So it's not completely unheard of for commissions at the county. In a way, it's a similar sort of sensitive topic. I would say that if the commission wants to have people testify under oath, go ahead and do that.
2 of the other counties that Kristen sent us do require an oath. So,
I think it makes sense. It just, I think,
Right.
lends to the gravity of what's going on.
right.
I'm good with an oath. All right. Where does that put us starting now on new material?
There was a whole section.
3.8?
Yeah, that's the one.
That seems to be in conformity with the law, so I don't know that we need to change that, and 30 days is certainly a reasonable time.
What does the charter say about civil sanctions?
Not sure it says anything about civil sanctions. So I sent to each of you last Wednesday an email attached to which was the charter provision that discusses the Commission and Oversight Office. I've resent it now to 2 of the 3, and Commissioner Murray, it's getting there. I've almost resent it. So it's going to your email at clark.wa.gov. You each have a Clark County folder, and that's where it's going. And it contains this provision. So if you have not reviewed those folders, if you haven't opened those folders, I strongly suggest that you do. But did I mess up somehow and you didn't get those? Because this will answer your question, Commissioner. The provision is in that memo.
Okay.
Probably because I've been looking at my regular where I've been getting these notices instead of the other ones.
So have I. I
Yes.
mean to look at the Outlook and I just hadn't done it.
So, Kristen, I suggest that you send all your things to the commissioners at their county email, not at a non-county email. And that
Yes,
will
I
make
have
it,
been sending them to both just to
Both
make sure that
places.
they stay in the county, but from now on I can do only county.
yeah, I would do that. Otherwise, they're going to be working harder if there is a public records request, because they'll have to search both their county folder and the rest of their email, which, you know, I don't know about you, but I don't want to do that ever.
Yeah.
So section 8.13 in the charter is a fairly short provision. And it says that the Ethics Review Commission is charged with hearing and ruling on complaints of violations of the Code of Ethics. It doesn't authorize any sanctions or punishment that I see.
Okay.
So who determines if there's sanctions or punishments?
Well, I'd say if somebody wants them, they need to amend the charter again and put that in there, or amend the code and authorize something under the code. There, I'm sorry, go ahead.
Well, I'm just wondering, what's the incentive to not, you know, if there's no sanction at all, why would a person care?
So I believe there are sanctions for employees who violate standards set forth in the HR policies.
Okay.
As to well, the code certainly seems to authorize things. The commission may take such action as it deems appropriate, including but not limited to public admonishment, public resolution of censure, or, this is great, any action as allowed by law. Whatever that is. And then if the commission finds violation by a county employee, the county manager may take additional action as allowed or required by county policy and or an applicable collective bargaining agreement. So that further is there. As to, for example, a violation found that was committed by an elected official, that would be found in a public hearing. And I would say at that point, the voters, you know, you can do your public admonishment or censure. And then that's out in front of the voters.
Yeah.
Including potentially for a recall.
But you said if there would be an admonishment or sanction, right?
Okay, the code says, if the commission determines that the violations are substantiated, the commission may take such action as it deems appropriate, including but not limited to public admonishment, public resolution of censure, or any action as allowed by law.
Okay.
So this is filling in what is a blank in the charter. The charter never says, so the commission finds violation, then what? It just doesn't say anything. So I don't think that this is necessarily inconsistent with the charter.
Mm-hmm. That's kind of what I've been thinking too, as I've been reading it. I almost think that for this section, everything after the first sentence just gets deleted.
In 3.83 or 3.81?
3.81 through 3.
Oh, okay. Okay.
And that's what it looks like to me, because I don't think we want to be writing findings of fact and conclusions of law.
Right.
I think if we're doing a written decision, I don't think we need to do a separate final disposition.
No, I don't think we have the authority to.
And then I don't think we have the authority to tell them that they can seek judicial review unless the charter has adopted those RCWs about this, but I don't think they did.
think there should be something about how that decision is conveyed to the participants. It's here by certified mail, but obviously you could do it in, way, but it doesn't, it's not requiring us to notify anybody in any particular way.
Yeah, good point. So maybe the number one ought to end after allowed by law, and then as allowed by law, sorry, and then a number two that says a copy of the written decision
Yeah, please.
shall within a reasonable time be served by certified mail to, yeah, then just pick up the rest of that.
Yeah,
Right.
I'm sorry, there's nothing in here that says you have to do a final written decision if you're leaving out that part about findings of fact, conclusions of law, and an order containing the final disposition.
The first sentence of 3.8.1 says that we're going to do a written decision.
Okay, that's whether to issue. I would, having been to court a number of times regarding an administrative decision, I would strongly suggest that you include findings of fact and conclusions
In the
Findings of
written
fact and
decision.
conclusions.
in your written decision.
Okay,
And you don't have to say conclusions of law. I think that's, but findings of fact, if you don't have facts on which to base your conclusions, and if the facts you find are not supported by evidence, then under the Administrative Procedures Act, that's a big problem.
Right.
okay. So then maybe we keep most of that paragraph.
Though you might want to make that big set of phrases into a sentence, the one about the findings of fact and conclusions of law.
we're taking out the of law. Because we're not, taking it.
So start at finding with a capital F.
How about the commission shall adopt findings of fact, conclusions, and an order?
I'm good with that.
Or how about the decision shall include? Because it, right. In the previous sentence, it says there will be a written decision.
Oh, yeah, so we're repeating, so, yeah, the decision shall include.
Let's think about that for just a little bit, a step farther though, because the first sentence says the written decision is going to be whether to issue one of these things that comes from the code.
Okay,
Right, but your decision is gonna be based on the findings of fact and conclusions, right?
right. So your written decision would include your findings of fact,
Right,
conclusions based on the evidence.
right.
Okay, I'm fine doing it that way.
Okay. Did we thoroughly confuse you, Kristen?
I think I'm okay, but let me know if I think the changes are in there now.
Okay. And we're leaving in the certified mail or some other manner?
I
Just
think
out of curiosity, do you want it to be posted on your webpage?
Yeah, I think so.
I don't think it needs to be sent by certified mail to be valid. If, you know, you send it, the person who sends it certifies that they sent it on a particular day, it's done.
Okay.
Me.
I don't know, I've just been involved in those cases where the person said, I never got it.
They say
Might
that.
have sent it.
They say that all the time.
I know. I know they do.
As I say, if the person who sends it just has a certificate of service or delivery or mailing, a certificate of mailing is a good thing, then I think that serves the same purpose.
Yeah, and I also think the certified mail would be more important if we were going to keep the appellate process, because that would trigger their clock ticking on their right to appeal. But since, as far as we know, our written decision is the end of it, then I don't think it really matters. And then I think it's up to them whether they get it or not.
Oh, the written decision has to be appealable. I mean, you can't find somebody guilty of an ethics violation and that's the last you get to say.
Well, where's the structure about how it's going to be appealed?
Well, the number 2 says may seek judicial review in the manner and form.
Yeah, I thought there was, according to the code or statutes, there was the appealable.
We don't have authority to expand the jurisdiction of the courts, so we'd have to check that RCW and make sure it applies to our commission. So, Christine, do you want to do that?
Sure.
Okay.
I think that I think that Superior Court gets to hear and rule on appeals of administrative decisions.
Okay.
But I am paging through my RCW even as we speak. So,
All right. Yeah, as long as we're authorized to do that, then I think I'm good with it. If we're authorized to trigger that RCW.
okay, so that's interesting. The RCW is in a chapter called Campaign Disclosures and Contributions. But this just says in the manner. Oh my Lord. I'm gonna have to get back to you on this.
Okay.
Okay,
That is a very long statute and it has lots of things that aren't not relevant.
okay.
Okay. So if you can find whatever appellate process we can trigger, and then I suppose as far as 3.83 goes, that's going to also be under whatever authority you find for that, the time that they have to perfect
Right.
an appeal.
Right.
But
I
I
would-
thought we were taking out 2 and 3.
But I think we're thinking we need to leave them in. Because they're,
I thought
as
because
Christine
they were
said, there has
already in the code or the charter and the RCWs that we were not repeating them, but it's okay with me if we're just repeating.
There's absolutely nothing in the charter.
Oh, okay.
I can certify as to that. You know, when people don't like what the county government does, if nothing else, they can file for a writ of review or a writ of mandamus. So there are remedies at the court, I believe, that might apply. I will look further.
Okay. Yeah, we just need to figure out, I think you make a great point, Chris, that it should be appealable. And since we don't have authority to do it, if there's a statute already that lets them get into the court system, then that seems really appropriate to me.
I will check it out and get back to you.
Okay. And for the non-lawyers who are here, I suppose we should say a little bit about why this is concerning, because the courts don't really have authority to just hear any kind of case that's out there. There has to be some law that they act under. And since our law doesn't say that it can go to the Superior Court, we'd basically be telling the Superior Court, we've decided as, 3 people appointed by the county council that you're going to start hearing new cases.
I'm sure they'll be happy with that.
I'd be really happy with that. Yeah. We just have to make sure we're triggering the right law so that whoever goes to appeal doesn't just automatically get kicked out. Chris, is that the way you describe that also?
Yeah, that makes sense. Just let me take a good look at it between now and your next meeting. And I may send you something via email. I may send you a memo, or I may just wait until the meeting, depending.
Okay. That works for me. Darcy and Barbara, you guys?
Yeah, that works.
Good.
All right. So on to advisory opinions. We were just going to take out advisory opinions, I think.
Right.
So then on to meetings and public participation.
I had nothing that I thought should change, but
All right, give me a second to refresh my memory and read back through it here.
Makes sense to me.
Yeah, I think, let's see here. Yeah, I think that all looks good to me. On to executive session then.
okay.
Sure.
I had no changes.
Yeah, I don't either.
Do we need to define what topics are appropriate in an executive session?
So that is one thing I was thinking about, but those topics are laid out fairly thoroughly in the Open Public Meetings Act. I
Right.
have to say thoroughly and at length. And y'all can't violate the OPMA. I would just leave it in there.
No, I think so.
Yeah, it says at the end for topics allowed by state law, so we should just all make sure we're familiar with what those topics are. But Chris, you'll keep us
Yes.
in
And,
alignment.
you know, you might want to actually put that sentence at the very beginning of the paragraph to kind of frame what executive session does. It's for topics allowed by state law.
I like that.
The only thing I wonder is, I know in school districts and the college where I've worked before, we always had to state for what purpose we were going into executive session.
Yes, and this says that when the chair convenes the commission into executive session, the purpose and expected ending time will be announced.
Right.
There is one other thing that has to be announced, and that is when the meeting reconvenes, because it must reconvene into public session after executive session, whether there will, yeah, that's not how I was thinking, Kristen. You have to announce whether an action will be taken by the commission on the matters discussed in executive session. In other words, will there be a vote afterwards, a motion and a vote based on your executive session material? Usually the answer is no, but that's another thing that needs to be announced.
But final action might be the sanction, the actual,
You don't get to discuss that in executive session. That's not one of the things that's
right, but
allowed.
so give an example of what might be discussed in executive session.
So, what might be discussed in executive session? I'll just say there is pending litigation. You
Right.
made a decision, somebody doesn't like it, they appeal it. This would be an opportunity for your attorney to talk to you, inform you about the litigation, answer questions that you might have regarding it, give an opinion on its strengths and weaknesses,
Right.
but there wouldn't be something you would need to do afterwards.
Okay.
And there is a section of the OPMA that specifically says you're allowed to talk about pending litigation. So that's 42.30.110 something or other.
I know that the language in that statute is very specific and lengthy, but it seems to me that it might be useful to just have a sentence that states, like, litigation, the reasons that you can go into executive session.
In this section,
Well,
I mean, I think if you reference the state law, you've included everything in there. The state law changes and allows something else. You don't have to go back and amend your bylaws to include that something else. You see, because the state has already,
right, I
Included it.
understand. I guess I'm just having trouble getting out of my past experience where we were very specific about that, but
it's still very specific. It's just another reference rather than included in the bylaws.
right, so when the chair announces the purpose of the executive session, the chair's gonna have to know,
Right.
right?
Right.
Okay. All right, and where are they gonna get that?
It'll be on the published agenda.
Oh, the purpose, okay.
Yeah.
So it will have been predetermined. Okay, got it.
To discuss matters related to RCW, blah, blah, blah. Yeah.
Okay,
I appreciate your desire for specificity, because that is, I think, very important to the public to be able to know.
right. Okay.
Are we moving on then to the next section?
Sure.
Last section?
Was there something that you wanted to add in the beginning?
Beginning of what?
Or
Oh,
in the
that-
very beginning of 5.2, I thought I had heard wrong, and then Chris corrected me and said that wasn't what she had in mind.
I would take the very last sentence in that paragraph and make it the first sentence.
Mm,
But that's just what I would do.
mhm.
I agree with that.
I do too. I think that's a great idea.
Okay. No
Okay,
problem.
thank you.
Okay, so then we need a new,
This would
trying to decide
be,
if this is a new heading or a new section or a new subsection on amending the bylaws. Meetings and public participation. I think it's a new section. Does anyone else have an opinion?
Yeah, I think it's a new section, so it'd be what, 5.3?
5.3, yeah. Or no, I'm sorry, it would be Roman numeral 6 if it's a new section. 5.3 if it's a subsection.
Okay.
Or actually, let's consider for a second whether this might go back up somewhere else. No, I guess it doesn't. I was thinking there. Oh, here we go. Quorum. 1.4 is quorum and voting.
I don't think it necessarily goes there.
Yeah, I don't think so either. All right, new section then, new section 6.
Mhm.
So just generally should, it seems to me that any one of the three of us should be able to propose amendments, and then the amendment is adopted by majority vote, would be my initial thought. Anybody else?
I think that's it. Does it need to have public notice or just a notice in the meeting, notice of the meeting? The agenda.
Well, yeah, there should be notice. So we're gonna allow public participation. So there should be notice. What kind of notice goes out about
Yeah,
our
we-
agenda?
Well, that all depends on whether you, it looks like you're adopting a schedule of regular meetings. Typically, when it's regular meetings, the county publishes notice 15 days in advance and posts on its website 15 days in advance. If you're having quarterly meetings, that's, there should be time to do that.
Okay,
So we just, that they will be, or, the amendments will be voted on or discussed and heard, voted on according to whatever section of the charter or the code that applies. That way, if changes go as to what needs to be published, we're not having to change the bylaws again. If we're
Yeah,
just referencing a
I
code
would-
or a county charter.
Yeah, I would not put the notice of a proposed amendment here because there's nothing in here about the notice of the agenda, is there? Or is there?
so we have that back in section 1.2, it says
Yeah,
it'll be produced for all meetings.
posted, so forth and so on.
And can we just reference that back, that amendments to bylaws as proposed by commission's members shall be in accord with the procedure for meetings in section 1.3?
Um, 1.3 is just about the type of participation, just hybrid versus in person.
Well, it says that you'll have open meetings. It says that you'll have an agenda. You'll said that you have minutes. So it is
Yeah,
somewhat
that's
on how you're conducting the
1.2,
meeting.
but that's all right.
What is the proposed language for the amending bylaws? I'm not tracking what the actual proposed language is.
I don't think there's been any proposed language. I'm just suggesting that it be something to the effect of amendments to these bylaws may be made from time to time upon, I don't know, on motion by any commission member in accordance with whatever procedure for handling meetings that you want to reference. I just don't think you need to set out a special, it's going to be in a meeting, obviously, that somebody has proposed, that Darcy's come forward with something we need to look at. So we look at it and then we decide on it, and then we reflect that in our minutes. It's just another subject in a meeting, but I don't need, we need special meeting procedures to do it with.
Right, as long as there doesn't need to be public notice of a change and then address it at the next meeting. But if there doesn't have to be public notice, then I agree with you.
But there would be public notice because we have to post agendas.
So it would be in the agenda. So I mean,
Yeah.
what I'm getting at is you can't in the middle of a meeting just say, oh, by the way,
Let's change 5.2.
yeah, let's
Right.
change 5.2.
Yeah.
I mean, it has, okay, yeah.
Yeah. But I'm saying we don't need to reinvent the wheel here for a special meeting to have bylaws. It just needs to be held in accord with either state law, county law, or county charter, whichever applies for meetings. And it just needs to reference those authorities.
Okay, so I'm watching how Kristen's translating this into a provision.
Well, you have better eyes than I do.
Thinking an ordinance with a state law or
Well, with applicable statutes. And county code. Or charter, or.
That covers it. Seems like.
Well, it does, but it doesn't really, it doesn't say who can propose an amendment, and it doesn't say what percentage vote is needed to adopt an amendment. So I think we should add those.
Well, it says they can be made
I guess
by
it says by the
members of the
commission.
commission.
Members,
Members
yeah.
of the commission.
By majority of.
And adopted by a majority of the members present.
There you go.
Which gets us back to the problem with only having 3 people.
Yeah.
If
Yeah.
somebody's gone.
Well, we get to hold it for the next meeting then.
Well, yeah, and what we, I mean, and that was part of the public comment. So, where we ended up with that last time was we're all a little uncomfortable with it. As I understood it, we were all uncomfortable with it, but we felt okay about the idea that it still requires a majority. So
Yeah.
you're going to need 2 people to approve something, whether you have 3 people at the meeting or not.
Right.
So it's not ideal, but it's not as bad as I thought it was before we thought of that point. I can't
Yeah.
remember who brought that up, but okay. So does anyone else have anything in addition that they think should be added to these bylaws? And the reason that I ask is because what I'm getting at is, do we want to go ahead and just make a vote and adopt them now? Or do we want to take some more time? And I kind of lean towards just adopting them now if everyone agrees with them, because we now have a provision that allows us to amend them if we find mistakes later. Does
My
anyone-
preference would be to look at a clean copy again. Just because if it's just, we've left out 3 words someplace, we have to have a meeting to amend it and a vote and notice. If we have
Yeah.
another clean copy and put on the adoption next time with any corrections, which may be, the tense, or it's too many words and not the right words, or somebody forgot the verb.
Yeah, I think that's a good point, and I'm happy to go that way. I just want to just push a little bit, because part of the thought I had about adopting them now is that then I think we have a procedure where we can ask if anyone who's participating today from the public wants to say anything. We could open that up before we adjourn for the day.
That's true.
And then we could do our amendments to fix the typos and things later. But I'm also totally fine if we want to wait another round for that. But my interest is just in getting the public involved as early as possible.
I can go either way, Adam.
I think you make a good point, Adam. I would be in favor of that.
So are you making a motion?
I move that
Second.
that we approve these bylaws. Correct? Is that all we need?
Seconded.
Okay, so there's a motion to approve the bylaws. Those in favor say aye.
Aye.
Aye. Those against say nay. Okay, the ayes have it. So we have bylaws. Congratulations, everybody.
Woohoo.
Okay, so now let's follow our bylaws.
I would like a clean copy so I can see what I'm doing here.
Yes, yes, I'll send out a clean copy, and then I know we talked about just making sure the spacing and everything is consistent.
Right.
Mhm.
Right.
And
And
Kristen,
capitals, yes.
you'll post them also on the commission's webpage?
Yes, yes.
Super.
I probably can get to that tomorrow.
Good.
All right, so pursuant to section 5.1 of the commission's bylaws, we've now reached the time that we're open for public input. If anyone wishes to speak, please turn on your microphone and let us know.
Okay, and it looks like I do have Bridget McCleeman online. And we talked about a 3-minute timer here in the bylaws. Is that something you would like me to have up on the screen?
That's a great idea.
Yeah,
Okay.
I like that.
Okay, wonderful. So Bridget, I'm requesting to unmute you. I think you'll have to click unmute and then you can go ahead.
Everybody. I was hoping to comment before you adopted the bylaws because you've skipped over the part where the bylaws have language which is in conflict with the county code. And it would have been appropriate to have a motion from the Ethics Review Commission asking the county councillors to review the council ordinance, which is what got enshrined in the code and has left out a little piece of the charter. So I think it would be appropriate for the commission to ask and to have their answer on that prior to completing the bylaws, but maybe that's too late now. It would also be appropriate to ask them, if you felt it necessary, to review the number of people on the commission to increase it to 5 rather than 3, given how much discussion there's been about the difficulty of different motions with only 3 people and recusals or absences and that sort of thing. But otherwise, thank you for joining the commission and being there ready to go to work. Thank you. Bye.
Thank you.
And it looks like that is everyone we have from the public online. The other members are other staff from my office.
All right. Darcy and Barbara, do you guys want to talk about those comments at all before we adjourn, or do we want to stew on them until our next meeting? Stew's not the right word. That sounds negative. I didn't mean it as negative. Cook on them, you know.
Responsibly, right? I don't know what. Anyway.
I guess
Some other word. I appreciate the comments. I don't know that we have the authority nor the position to increase the number of people on here. I think that's the county council's decision.
Mm-hmm. I think the comments were geared towards encouraging us to maybe write a letter to the council asking them to fix some of the issues that were in the public comment that she sent in. Which I don't think we necessarily need special authority to send them a letter suggesting something like, hey, this might be hard to do with 3 people at some point. So I think it's something we can consider. Let's put it on the agenda for next meeting to talk about
Okay.
what we might want to say, because I would like to spend some time after talking about the public comments with you guys today. I'd like to spend some time going back over the charter and the code, because I was really in the mindset of the code, and I think the point that the charter supersedes is a good one. So I just want to spend some more time looking over the charter and kind of thinking about that. But I like the idea that maybe we do at some point send a letter to the counselors saying, you know, now that we've met a few times, here's the problems we've identified. Please fix them.
Yeah. That's good.
I agree. I want to spend a little bit more time thinking about the inconsistencies that were brought up. So, yeah, I agree completely.
So Kristen, can you put that on our agenda then to talk about next time in case we forget?
Yes, I will.
Thank you.
So will we be going into our regular schedule of quarterly meetings, or are we still doing preliminary meetings? Kind of getting our act together.
I kind of feel like we need at least one more of these preliminary ones. Do you guys?
I'm not sure. I mean, I'm willing to go to it. I'm just not sure what the subject would be, because we basically don't have anything to decide.
Well, I think if we were to do another one, there would probably be 2 things. One would be, did we spot any problems with the final bylaws that we need to amend right away? And then do we want to put together a letter to the council about where we see slippage from the charter to the code.
Mhm. I think those are two topics that are worthy of a meeting.
Okay.
All right, let's do another one then. When should we do it?
Let's see.
April 10th now. You want to go about a month out, or is that too long?
How about May 9th?
May 9th.
May 9th.
Yeah, I could do May 9th.
Right, what depends on the time.
So I am actually out of the office May 9th. I don't know if I need to be there for finishing up edits of the bylaws for you all. I'm sure I can have another staff member step in too, but I didn't know if me being the one doing the edits, it was necessary.
I would think at that point that we're just going to be looking at typos and things like that.
Perfect. Okay, I just wanted to make sure everyone was okay with that.
I think that's okay. Barbara, Darcy.
Yeah, I'm fine with that. Again, depending on the time, I've got a salary commission meeting that night, but
2
if we
o'clock
do the
again?
2 o'clock, that would be fine, sure.
Okay.
So it's a Tuesday?
Yeah.
Okay.
Okay, perfect. I will get the meeting notice out here pretty soon and then, yeah, get the link all out.
All right. And so then I guess the three of us need to get serious about our county email accounts.
Yes.
All right. Anything else for the good of the order?
Nothing?
I don't have anything.
Okay. Meeting adjourned then. Thank you, everybody.
Thank you.
Thank you.
See you all in a few weeks.
Oh, I'm sorry. I just wanted to clarify one more thing for the agenda for the next meeting. Chris is going to give us information about the appeal process.
Oh, that's right. Yeah.
That is on my list.
Okay.
Okay.
Okay. So that'll be an important one. Okay.
Okay.
Sorry. Okay. Back to anything else then for the good of the order other than that?
No?
I think
We
we're
adjourn
good.
again? Look, we adjourn again?
We could adjourn again.
All right.
All right. Have a good week,
Bye.
everybody.
Thanks.
Bye.